Welcome back. Former President Jacob Zuma and arms manufacturer Thales have suffered a legal setback. The Pietermaritzburg High Court has dismissed their bid to have charges dropped in the long-running multi-billion rand arms deal corruption matter. For this, we are joined by legal analyst Ulrich Roux. Mr. Roux, thank you for your time and for joining us this evening. So maybe what do you think is the significance of the Pietermaritzburg High Court in terms of this recent dismissal of the application by both the former president and the arms manufacturer, rather, pardon me, with regards to this leave to appeal being dismissed?
Well, firstly, I think it's the right decision that was made by the court. Their application was for leave to appeal the earlier judgment by the court to force the NPA to withdraw the charges and to stay the prosecution. Their main argument was that they cannot present their case adequately, and accordingly, their rights to a fair trial are being impeded upon, because two of the witnesses who they would have called as defense witnesses have passed on and are no longer able to testify. And the court correctly pointed out that, this is a circumstance that's unavoidable, but it does not detract from the allegations that have been leveled against them. The court, secondly, also looked at the main cause of the delays. This matter, Mr. Zuma was first charged in 2005. So this matter has been dragging on for 21 years. There have been some delays on behalf of the NPA, but of late, and since the charges were reinstated against Jacob Zuma in 2018, he has done his utmost to delay this matter and to frustrate the proceedings. And the court, in my view, correctly pointed out that regardless of the unavailability of the two defense witnesses, the matter must still proceed. And, if the accused are innocent of these charges, then they shouldn't have a problem in adducing evidence and showing that their versions are reasonably and possibly true. So one has to wait and see whether even a further delay tactic is employed by Mr. Zuma and by Thales. They could approach the Supreme Court of Appeal on this decision, and chances are that they most likely will. But for the time being, the charges still stand, and the trial must still commence.
I mean, the prosecution has described this with what you're saying now, that they most likely will appeal as these stolen grant tactics. What do you think these type of tactics do, especially when setting a precedence for future cases?
Well, it shouldn't. The Constitution is clear that every accused person has the right to a fair and a speedy trial, but the Constitution is also clear that, matters must be handled as swiftly as possible. And in our Criminal Procedure Act, we have what we refer to as Section 342A. And if the accused are guilty of deliberately delaying a matter and frustrating the matter and delaying the finalization of the matter, then they could very well be held in contempt, so to speak, and they could be placed, remanded into custody. So in other words, they could be jailed until the finalization of the matter. We see that happening quite often in our criminal courts in South Africa, and it is unfortunate that this is the situation. Once again, as I said earlier, if an accused person such as Mr. Zuma is confident that he is innocent of these charges that have been brought against him, then he should welcome his day in court in order to prove his innocence. And then if he is found not guilty, he would obviously have recourse against the National Prosecuting Authority as well as the South African Police Services in the form of a damages claim. And even though Mr. Zuma has said on numerous occasions that he wants his day in court and he wants to show the entire country that he is innocent of these charges, he keeps on delaying the commencement of this trial. Now, charged in 2005. It is now 21 years later, and this trial has not even commenced yet. So evidence has not even been led in this matter. It's all been preliminary hearings and applications that have been launched, and unfortunate in my view. This should set no precedent going forward, and our Constitution should remain clear that matters of this nature and criminal matters must be finalized as soon as possible.
And with that thought of saying that evidence should get to a point where it is led in court, I mean, Judge Nkosinathi Cili said and found no compelling reasons to grant this leave to appeal. What do you think this statement by the judge imply about the strength of this case?
Yes, so the difficulty lies in the fact that you cannot force or seek an order where a court forces the NPA to withdraw charges against an accused. Now, we have the separation of powers doctrine, and that states very clearly that the judiciary is completely separate from the prosecution as well as the South African police services in order to uphold that separation of powers doctrine. And that is what the judge found today, is the order that they are seeking is that the NPA must be forced to withdraw the charges, but the court cannot do that. Once again, the recourse for the accused, should they feel that they've been subjected to a malicious prosecution and that the charges should never have been leveled against them and the matter should never have proceeded, then they are very well within their rights to institute a damages claim subsequent to the finalization of the matter. And if they were indeed correct in the summation that it was a malicious prosecution, then they will be reimbursed accordingly and they could be successful in a substantial damages claim. But the very relief that they sought from the judge, in my view, is wrong. They cannot force the judge to force the NPA to withdraw the charges. And that is why he correctly pointed out that, the application for leave to appeal today must fail and the matter must proceed. I don't think that he went into the merits so much. The trial has not started yet. So, in fact, he is prohibited from going into the merits. And once again, the NPA has decided after numerous years and numerous applications being launched against the NPA, the NPA still stand fast and hold true, saying that they have a strong enough case and that they can prove these charges beyond a reasonable doubt. And that is what is before the court. The court cannot now force them to withdraw those charges. So yes, once again, in the eyes of the court, the charges still stand, and the case is strong enough for the NPA to proceed, and they must accordingly do so.
And do you think this will now influence the pace and the future for the trial process?
It should. The investigations have been completed long ago. The state have indicated, I think 5 years ago already, that they are ready to proceed to trial. So it should, but unfortunately, as we have seen in the past, and as is Mr. Zuma's track record, there is most likely going to be an appeal lodged at the Supreme Court of Appeal in Bloemfontein, which could take another 6 to 12 months to finalize. And once that has been dismissed, and if it is dismissed, then one can expect this trial to commence. And finally, for evidence to be led, then the state needs to produce or present their case. They need to call all their witnesses in support of the charges that they have leveled against the accused. And once they are done, then, the defense will be entitled to produce or present their case. Then Mr. Zuma could very well have his day in court that he has longed for and proclaimed he wants for such a long time.
21 years later. Just on a broader perspective, how do these decisions that the courts make influence particularly the public perception when it comes to the justice system and how it handles corruption cases, and especially corruption cases that involve high-profile figures?
Yes, so certainly, the court needs to send out a strong message to the South African public, and the South African public must have faith in our judicial system that if someone does commit a crime, that they will be prosecuted successfully and that they will accordingly be sentenced, should they be found guilty of that crime. And that's a big problem, and it's a good point that you've raised. I think the South African community has lost faith in the judicial system, in the fact that this matter has been dragging on for such a long time. This arms deal was concluded in 1999 already. So we are approaching the 30-year mark since this alleged corruption took place, money laundering, fraud, corruption. Those are the charges that Zuma and Thales is facing. And certainly in an ideal world, this matter should have been finalized long ago. Jacob Zuma's financial advisor at the time, Mr. Shabir Sheikh, was found guilty, and he was sentenced to 15 years imprisonment based on the same charges. And that was dealt with quite swiftly. Mr. Zuma, obviously, he then served as president for 2 terms of our country, and that delayed this matter. And after the charges had been withdrawn against him in 2009, they were then reinstituted again in 2016, and he was charged once again in 2018. So certainly this is not an ideal case for the South African judiciary and for the National Prosecuting Authority, and certainly this is not the norm, and even though I said that the South African community has lost faith in the judicial system as a result of this case, this is certainly not the norm. We have very hardworking prosecutors, we have very hardworking policemen who try to ensure that justice is not only done, but it is seen to be done. And this matter is most certainly an exception to that. But the South African society must not lose faith. The matter is still on the court's roll. It has obviously taken much longer than what it should have. But Mr. Zuma is still an accused person in this matter. And, if the evidence proves that he is guilty of these charges that have been leveled against him, then he should be convicted and sentenced the same as what any other member of society would have been.
All right. Well, 21 years and 8 applications later, we're still to hear evidence in this case. Thank you so much for joining us and giving us that legal analysis. That was legal analyst Ulrich Roux.